like every single day, pretty much. Public Auditor BJ Cruz. And it's funny, when he comes out with these audits, there's always the other shoe that we wait to drop, the shoe of, hey, is anyone going to do anything about this audit I just did that all these red flags in it, that we did all the research, everything's pretty much backed up by fact and findings, and here it is, everybody. And, well, we don't usually see things being done, but this latest audit that came out, I mean, it was like, resignation was just part of the fallout, if you will, talking about resignation of the Contractors Licensing Board. Ironically, his nickname is Buddy. Yep, Cecil Buddy Orsini resigned Friday. Public Auditor BJ Cruz in the KUAM News link, a Zoom room. Public Auditor, good morning, first of all.
Good morning.
We didn't get to get your reaction to the reaction JMI Edison had to the audit and its findings, and well, here we are. So, Kuya BJ, what is your reaction to that statement?
I'm not going to react to it. I'm not manipulated by anybody. And it really is disappointing that and troubling that all of this had occurred. And unfortunately, the one that suffered was the director. And I really don't, I think he was at fault, but also at fault is the fact that the board hasn't met. And I'm not even sure, at least from the testimony that we've received in another case, whether or not there's even a quorum of the board to meet. Our records show that the last time the Contractors License Board submitted their board meeting minutes to us or recording was last September. And that coincides with the testimony that was given in another case before us that dealt with this very same issue, a license, whether or not a license was required of a bidder in order to be able to get a contract to do some services for one of the government agencies. And the thing that upsets me the most is the fact that if anybody listened to the tapes from both of the hearings, they'll be surprised to find that actually I was very sympathetic and understanding of the issue that was being raised about the need for a license. And I just needed evidence to be able to either evidence in affidavits or evidence at hearing that there was in fact a need for a license. In the other case, they filed a very similar document, almost identical to the one that was filed in this case. And so because I received that, I didn't dismiss the case for lack of stating an issue, because I thought there was a fact at dispute of whether or not there was this requirement by the Contractors License Board. So we went to hearing in the previous case. And in that previous case, all of this happened around the same time. It was all Christmas week. We had the hearing on December the 20th, and on the 20th, a investigator from the Contractors License Board came before us and was testifying. I mean, I was surprised that it wasn't the director, but whoever the parties, I mean, you know, it's up to the parties to present the evidence and the witnesses that they want. They had a investigator come before us, and when she testified in response to questions by interested parties counsel. She testified that the board hadn't had a quorum since last April, and the last meeting of the board was in August of 21. And you know me, and everybody knows me, my face is not a poker face. when 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 she testified to that, you could see me almost cringe and jump out of my seat. And I looked at all the council and I'm, what? There hasn't been a board meeting since August, and now I have this findings of fact purporting to be the findings of the board signed by the director. And I just looked at the two of them and I said, all right, fine, I'll just take this up. I am matter under advisement. This was the 20th of December. The 23rd of December, I get an almost identical document filed in this case. And I was fuming. I thought, oh, wow, what is this? They look alike. And I said, all right, fine, that's good. At least now I have an issue. And so when we had the first hearing on the 27th, there was counsel in the hearing representing the airport that wasn't at the previous hearing on the 20th for the other case. And so I decided to continue the hearing until January the 6th, figuring that the three attorneys would sit down and they would talk to each other about what the testimony was in the other case and to tell him how I reacted to that testimony and what concerns I had with that testimony, and whether or not we should go forward. We came back on January the 6th, and unfortunately the attorneys weren't able to get together and discuss this. So I continued the hearing until January the 27th. I continued the hearing until January the 27th. So on the 24th, Menzies' attorney filed some documents in the case saying they had a FOIA of the CLB, and this is what the CLB provided. When I looked at it and I saw that it had been asked for by the party and had been, with those emails, I was fuming for 3 days until the hearing. And so on the 27th, I opened the hearing with, a sort of statement asking counsel, do they have a motion for me? I was hoping that they were going to withdraw the whole case and ask that it be dismissed because they had been caught with their pants down. And instead, counsel doubled down and insisted, that the orderly process of government demands that you grant collegiality and probity to all the other agencies and boards, and that you're bound by a decision made by the board. And I just said, what? I said, all right, fine. Go ahead and argue your motion, since you're not going to make the motion that I was hoping for. Argue this motion. So they argued it. When it was done, and it just came, it was very clear from the emails and the similarity of the this to the other case, and the fact that the board hadn't met, how could a decision come out? And so that was the reason why I dismissed it.
Oh, stand by.
BJ, you mentioned another case aside from this particular one with JMI, the GS4, I believe was the other case.
Yes, G4S.
G4S, I'm sorry, the release said GS4. So was that also dismissed with prejudice?
I haven't issued that decision yet. I'm about to. I'm writing the decision now, but I guess I've announced it now. But because that one, really seriously, I wanted to, as I mentioned earlier in this interview, I really was understanding this argument, and I thought that I was going to be issuing a decision in both cases that there's this need for specialized licenses to be provided, right up front in packages in the bid package, because this office in 2015 and also from court precedent there's a ruling that says that certain documents can be provided up about the time that when you get the contract, like in order to encourage off-island bidders and not to exclude anybody. A business license isn't, might be a requirement, but the fact that it's not in the package is not fatal, because they can, when they sign the contract, provide a copy of the license on that date. But that's a pro forma kind of license. There are specialized licenses, and in both of these cases, there was an argument that there was a need for a special kind of contractor's license, either C78 or C15. And, I was waiting for testimony to explain to me why these kinds of specialized licenses were necessary so that I could make the ruling. But then when I get the problem that there isn't a quorum at the board, that their board hasn't met since last September, the director's filing documents purporting to be findings of the board in two cases, it's very hard to believe anything. As I said in my decision, it just makes it difficult to accept anything from the CLB. I mean, like if your significant other lies to you on one event, or if an alibi somebody gives is questioned, and that or the alibi is a friend who to be a liar, you're not going to buy that alibi from your significant other that they were, watching Super Bowl or watching the Olympics. So it was unfortunate because I really was hoping to make new law in this case. Unfortunately, the new law that I made in this case is finding that the fraud had been committed upon the tribunal and had to dismiss the case. This was not the way that I wanted it to end.
Yeah. I'm just wondering, are there other instances like this that you think that we need to kind of look back on, given that what'd you say, the last board meeting was in April of September of 20?
Well, the last time the testimony was that the last time the board had a quorum was last April, and somehow the last time they attempted to have a board meeting was in August, and that jives with our records because we have they filed in September with our office a copy of their board minutes for the August meeting. So we were able to confirm that August was the last time the board met, or at least that's the last time they provided us a hearing minutes or a video or a tape recording. And that was a testimony of your investigator at the last hearing. So
during that August hearing, and since as you mentioned, you had the minutes, did it state that there was any action or discussion that was talking with regards to JMI's concerns that Menzies did not have this license or special license?
It wouldn't have, because Menzies didn't file JMI didn't file with a complaint with the CLB in September.
BJ, so if you're saying that the board hadn't met, but that Buddy Orsini had documents that look like they may have been approved by the board. Are those types of documents and things like that, are they able to be approved by a board outside of a board meeting setting?
Well, according to the statute, no, and according to the testimony of their investigator in the other case, it required the board action.
Right, by four members.
Yeah.
Okay. And none of that transpired in either the G4S or the Menzies cases that you.
So how many other cases?
Well, that's what the
the
fact and finding. How can
the
you?
Only two that are CLB that are currently before me.
Right. But like in the decision that you issued, how can you rely on anything that's come out of the CLB?
Yep.
Yeah, I mean, yeah, that unfortunate, because I would love to depend on them and recognize and as their counsel put it, be bound by their decisions.
Did you get a chance to look at JMI Edison's response?
He did. Yeah.
You did? Oh, okay, that's
he did. He said he didn't really want to respond. He did say a couple things, but just I guess BJ on that. What did you make of the explanation that they had for the use of the word bro?
I guess I was getting too cute in my decision, but it just bothered me that you could reach out to someone like that and ask to have something signed. And there, I will make one other comment on their statement. This is not, and I repeat, this is not like a findings of fact and conclusions of law that even I request all the attorneys to provide after a hearing. After a hearing, it is, here at the OPA and at the court, it is practice sometimes that the judge will ask the attorneys to, rather than listen to their arguments, give them the chance to submit in writing their findings of fact and conclusions of law as proposals for the consideration of myself or a judge. But that's after a hearing. In this case, I could find no hearing. And the request of this would really help our case if you could get this to us by the and then, I mean, findings of fact are immediately served on all counsel that are involved in the case. It's not clandestinely sent by someone and getting a response back from that agency and then sharing it. It's open, and the fact that this thing wasn't done openly also makes it very suspect.
Yeah.
Well, I'm not sure if you heard, but Mr. Orsini, he did submit his resignation to the CLB. So I'm just wondering, so what does this mean going forward now that this is supposedly going to go to the Superior Court?
I don't know what's going to happen with the resignation. I think it was most unfortunate that it came to a resignation, but that's a decision that Adler will have to had to make and did make. In the that the appeal can be are you still there?
Yeah, we're here.
You're clear now. Go ahead. Go ahead.
So I'm glad they're going to take it to the Superior Court, because then I'd love for them to to present it to a judge and explain it to them. And the one thing that I'd be more concerned about is the fact that when it goes over there, I'm not sure whether or not the judge is going to ask who helped write the proposed findings. And I'm praying to God that it's not an attorney.
So as it stands now, we may or may not have a contractor with the airport who doesn't have a license or specialized license that is required.
Can you kind of re-explain that, BJ? He kind of
Well,
talked
no,
about
I
that.
just missed the case, so they're going to be able to move forward with the contract.
So BJ, just I guess generally speaking, if a company comes from off island to do business here, at like what point are they required to get a business license or a specialized contractor's license or whatever?
They're required to have a business license by the time that they sign the contract. I mean, that's been the whole big fight that we're having in my other audit that's being done on the military contract, the contractors that are coming in to do the military contracts, and the fact that do they have licenses and are they paying their taxes? And so at the time that the contract is signed, you can make your presentation of the pro forma business license. But my concern, and if you listen to the tapes in the other case and in this one, what I was arguing with the attorneys was I can accept the fact that a pro forma contract can await a signing of the contract. That's pro forma. It's something easy. But if you're going to get a specialized license, like when my office made a RFP for hearing officers, it required a attorney license, a Guam attorney's license by the Guam Bar Association. And I can't wait for that until the contract. That has to be presented up front so that I know that person is qualified to take the cases. As I mentioned in both hearings, I said, my auditor that handles procurement probably knows more procurement law than anybody, but I can't hire him for a hearing officer in the same way that my predecessor needed the hearing officer to sit in in all of the cases because she was not an attorney. That's just a requirement. And that's not easily had. You have to take the bar exam. And so in something like that, where you have to take a bar exam, or if it's a specialized license, a C78 or C15, if they have to do something special to get that, I was hoping to be able to announce in both of these cases that yes, that should be a requirement that's provided in the bid package in the proposal, and that it has to be done ahead of time and not consider it like other licenses that are pro forma. But unfortunately, both of these cases are not going to be able to come up with that ruling because of it.
BJ, what did you make of JMI's assertion that they weren't afforded an opportunity to defend themselves during the hearing?
They were. I asked them, and they moved forward and did what they did. They argued it. You can listen to the hearing from the 27th. I mean, I asked, do you really want to move forward? Yes, they do. And Mr. Public Auditor, you're bound by the findings. And they insisted that what they did was right. So what more did they want?
This particular contract, is it a brand new contract, or have they had it, was this just up for renewal? And Menzies hadn't had a contract, I guess. I mean, a license for years?
the irony is that Menzies has had the contract with the airport for many years.
And for many years, have they been operating without a license, contractor's license?
Well, that was part of the argument, was that the contractors that they were never caught. And I was going to, when the airport argued that, I was like, someone has to file a complaint, and they have to come up and do that to look at it. And unfortunately, it wasn't done. But they both they and the other case insist that the contractor that they were giving that they selected had been doing this for many years, and there was never any requirement for a license. It's in the saying, they've been doing this ever since, and they didn't have a license. And I wanted to have a hearing that showed that there was, a need for a license. Unfortunately, the way that the issue was being brought was undermined the credibility of the board, and so I decided we couldn't move.
So what's more egregious here, Auditor, in your opinion, that they have been doing business without a license that you pointed out that they needed, or that JMI is burrowing their way through the system?
No, I can't say whether or not they are or they aren't. I mean, they've been handling it, and as was stated in their release, this is $1 billion corporation that's been doing it around the world, and can and should know what they need. And I was just hoping to make new law by saying maybe you did need to do something else here, but for the fact that the document presented to us was a fraud on this part. I decided we couldn't move forward. That their action was so egregious that the only thing that we could just do was dismiss this case.
Thank you, BJ. You good?
Thank you.
Appreciate your time this morning.
No problem.
Later on, bro. I mean, you can imagine going to court and be like, "Oh, come on, Your Honor. Sometimes we call people kuya, sometimes we call them ante, sometimes we call them pari, sometimes we call them bra."
Yeah, but was this company operating all along without a license?
I mean, yeah, but does that mean that we just give JMI the contract because I don't know. It's interesting. It's definitely juicy. But what else has been going on down there at the Contractors Licensing Board? Because there's been some things that have been happening relative to permits and approvals that were supposed to be have been gotten. Were they illy gotten? Illy gotten? I don't know.
I don't know.